Hello, everyone. Thank you for attending this webinar titled Interiors and Furniture, Understanding the Design Opportunities and Risks. Over the next hour or so, we're going to be talking about legal issues, contracts, and risk management, all as they pertain to interiors projects and particularly FF&E, design and procurement. And of course, we're going to be doing all of this in the context of the AIA's newly updated Interiors family of documents. Those documents, if you're not aware, are available at aiacontracts.org, and were recently published in the spring of this year, and it marks the first time we've updated the AIA's Interiors family of documents in the last 12 years or so. A few general notes. Please don't copy this presentation unless we have given you permission to do so. And also, this presentation qualifies for AIA learning units. So if you've registered for this and you intend to get a learning unit, you should get them within the next couple of weeks or so. They should show up on your account. If they don't show up, please just go ahead and contact us and we'll make sure you get credit for attending this webinar. A little bit about myself. My name is Mike Koger. I started off my career as an architect, and after a few years of practicing architecture, switched careers and started, practicing as a private practicing attorney. And in those few years before I joined the AIA, I represented all kinds of parties that were involved in construction contracts, contractors, owners, architects. But for the last 6 years or so of my career, I've been working at AIA National, where I work predominantly with the AIA's Library of Construction Contracts and do legal research and create and update the documents such as the ones we're going to be talking about today. Joining me on this webinar is Sal Verastro. Sal is one of the AIA's volunteer Documents Committee members. He gives quite a bit of his time, volunteers quite a bit of his time to help with the creation of the contracts that we're going to be talking about a little bit today. For a day job, Sal is a principal at Spillman Farmer Architects in Bethlehem, Pennsylvania. And if that wasn't enough to fill Sal's time, he also acts as an expert witness, representing and defending architects in legal matters. And for those of you who have ever been involved in a lawsuit, you know how important it can be to have an expert witness to defend you in claims of those nature. So, Sal, I want to just say thank you to you for all that you do with our program and all the time that you volunteer, such as the time that you're volunteering right now to talk on this webinar. Thank you very much for doing that.
Well, thank you, Mike. It's a pleasure being here, and good morning and good afternoon wherever you are to everyone. Welcome.
So I'm not going to talk much about the course and learning objectives that are on the screen. Presumably, you're all listening in on this call because you read these and it piqued something of your interest. I will talk about the agenda, what we're going to talk about over the next hour. We're going to start by talking about what makes interiors projects unique. And then we're going to do a high-level overview of the AIA's Interiors family, and then we're going to start going more detailed through different types of agreements and the issues you're going to run into. And we'll tell you how we've resolved some of those issues in the AIA's documents, but we'll give you some pointers if you're going to be negotiating your own agreements that are not AIA agreements as well. We'll talk about owner-architect agreements. We'll talk about a new purchasing agent scope of service that we've developed, and we'll talk about owner-vendor agreements. This is probably a good time for me to point out that I'm going to be saying the word architect a lot throughout this presentation, but we recognize, of course, that there are interior designers and folks who are not architects that are doing interior design work, and the issues that we're going to be talking about are, it doesn't matter if you're an architect or or an interior designer, you will run into the same issues. So one thing I would caution you, though, is if you're going to be using any of the documents that we talk about today, you'll need to make sure that you're representing yourself appropriately. So if you're an interior designer, make sure you do that. You don't want to get tripped up by, by using our documents and not changing those terms around. Just a quick overview. The AIA spends a considerable amount of time to update their documents and make sure we get things right. There are 25 to 30 volunteer AIA members who are largely responsible for updating and creating the documents in our library. These members commit to a 10-year volunteer commitment, and they spend a good amount of their free time working with us to make the documents as good as we can make them. And as always, we try to create documents that are fair and balanced as best as they can, and that assign risk in a balanced manner across all the parties in a contract. So with that, I am going to turn things over to Sal, and he is going to talk for a little while about what makes interiors projects unique.
Thank you, Michael, and again, welcome. Before I address this issue, one of the things I want to make sure everyone knows is that our task group, who was assigned to these interior documents, and it was a pretty large task group, one of the things we questioned is why aren't interiors documents used more often? It's a disproportionate amount of usage compared to normal construction projects, and certainly the work is not that disproportionate. And we attributed that to mainly it's an assumed perception of risk or lack thereof. What can possibly go wrong on an interiors project, being facetious there. But and we realized from our investigation, and Mike's going to talk later on about the liaisons that we spoke to across the country. A lot of them use letter agreements, which work just fine. So why would they need to use a document that or documents that we're going to talk about today? And then the other thing we heard on the negative side was the old AIA interiors documents were too complex. So we addressed those issues in these new releases. So, but let's take a step back and from 30,000 feet. So what makes interior projects unique? Why do we need specific contracts and agreements for interiors projects? And so again, what makes them unique? Next slide, Michael. First of all, typically the architect or interior designer is designing around existing conditions. Typically, not always. Sometimes it's a new building, but typically it's an existing building, a clean slate, so to speak, but the columns are fixed and the walls and windows are in place, and sometimes heights and things like that are dictated. And they can't be altered, so you're working around the situation that's fixed, unlike maybe new construction where an architect's working on a building. The projects can range from brand new, or in a lot of cases they're an existing building and it's being redesigned, repurposed, or in some cases it's a historic building. And then also there's several different scenarios that you have to deal with as an architect. You might be working with the original building architect in an existing building. So you as an architect will be working with another architect. You might be working with the original contractor of that building, which is another unique scenario, unlike what we're normally used to as architects. But you also might be working with a separate contractor. There may be a contractor for the building and a contractor for the interiors and FF&E. You also might be working directly for the owner or the tenant. Might be two different people. So there's a lot of players involved, which makes it very unique compared to our normal construction projects. And one of the other things that we have to address is that interior designers and architects with these kind of projects, you're dealing with existing conditions that may not be documented correctly. If it's an older building, you have to go out and resurvey, redocument it, and they may not be available. There may be no documents available. So it's quite unique just from that standpoint. On the next slide, you'll see so the term FF&E, and we want to make sure everybody understands that means furniture, furnishings, and equipment. We've heard it that it meant other things. This is the official definition of FF&E, and we're going to use that term. Unofficially, though, let me just explain quickly that FF&E can unofficially be described as everything inside the building that falls out when you turn it upside down. A lot of people ask us, well, what is FF&E? And the easy way to explain it is just that. There are some exceptions to that rule, obviously, like a chandelier or something like that. But we'll get into a more finer description later. The importance of furniture. We have a couple pictures there of unique projects where the interiors were equally as important as the architecture themselves. Furniture is many times, unfortunately, is an afterthought in our designs. We acknowledge that. It's not a good thing. We as architects should not go down that path if at all possible. But the Hall of Fame architects understood that furniture was and is an integral part of the building design process, and we believe that to be true as architects. But we've all witnessed how furniture selection and design can ruin a project if it's not done by a person who understands the total integral part of the design of a building. Furniture can make an average design better and a great project, a great design, even more awesome. Most architects prefer that the furniture should be part of the design, of the building design, and we definitely address that in these documents. So on the next slide, you'll see 3 examples of FF&E, loose furniture, obviously chairs and things like of that nature, tables. Furnishings, drapes, curtains, lighting, in a lot of cases are considered to be furnishings. And equipment, anything in the kitchen, loose items in the kitchen, copiers, office equipment, etc. That's really, when we talk about FF&E, that's what we try to get across the table of people. So let's talk about FF&E a little bit in a deeper dive. On the next slide, you'll see that what we want to talk about is contractors versus vendors. And this is where it gets even more unique. As an architect on a building project, I'm used to working with contractors. Interior designers and people who work with FF&E are dealing with vendors, 2 different terms. One has to understand that there's many parties involved in an interiors project typically. A contractor might provide the fixed interior design items, cabinets that are fixed to or in furniture that's actually fixed to the walls and the floors, versus vendors who provide loose goods, furniture, and the equipment that we discussed earlier. Those are loose, and those are goods. We'll talk about that a little bit later. The other thing is construction is perceived to mean fixed items, and delivery, FF&E items are delivered. Construction, fixed items are built, and FF&E items are delivered in most cases. But the other thing that's unique about those 2 things is they're both on different schedules. The fixed items, the construction of the building is on a different schedule than the FF&E, and they also have different budgets. We addressed both of those elements in the new documents, which was kind of overlooked before. And then lastly, the AE role, the architect's role. Architects now are going to be dealing with the vendor relations. We have an architect-vendor agreement. It's a new role for an architect. I got to admit, I had difficulty adjusting to this. This is a very new concept to me to deal with a vendor, much different than a contractor. There's all kinds of new rules. We'll talk about that as well. The vendor relationship is an important aspect in all of these AIA contracts, and you'll see that as we go through it. So let's talk about some of the contracts. We're going to get into a little bit deeper dive here now. Normally on a typical construction project, this building design, scenario 1 there, we would, where it's just exterior design, we just use the typical contract between the owner and the architect in the B101 agreement. Very typical, and there's also a B104. It's a little bit reduced scale. The scenario 2 is where you have mostly it's the building design, and now you have a little bit of interiors works. This works fine. You can still use the B101 in this situation. It works fine under these normal conditions. It's where you get into scenario number 3, it gets a little more complicated. Not only do you have the interiors and the exterior design, but now you introduce FF&E. Now you introduce a general contractor and a vendor who have to kind of work together and possibly at the same time. It gets even more complicated in scenario number 4, where we add FF&E procurement, where you will actually be an agent of the owner in procuring the furnishings, the FF&E. Mike's going to talk about that in detail later. We've got a document for that now. A lot of architects were doing that. If you provide these services, and I'm talking about scenarios 3 and 4, do you get paid for them? You should. A lot of people oversee this, and they don't get paid properly for it, and that's where these new documents come in. You're missing out on an opportunity, by the way, if you aren't providing these services and then billing for them and getting paid for them as well. Often the architects do perform them, and they don't get paid for them correctly. Vendors, the introduction vendors into our contracts is very complicated, and it is demanding on architects. It's not the typical owner-contractor architect agreement. We're going to talk about the agent and when you act as an agent for the owner a little bit later. But right now, Mike's going to talk about FF&E and why it's a different world out there.
Thank you, Sal. So as Sal's been talking about for a few minutes, the presence of vendors on an interiors project can't be understated. And the contracts, when it comes to contracts and owner-vendor contracts, you really get into some nuance, and you get into a severe departure from the type of language that we are used to, that I'm more familiar with in owner-contractor agreements. So, for example, when it comes to closing out a project and completion of a project, in an owner-contractor scenario, we think in terms of substantial completion, something that the architect certifies, there's a punch list that the contractor completes, and then there's a whole process for final completion. That process and that terminology is alien to an owner-vendor agreement. Most owner-vendor agreements are going to be couched in terms of delivery. Then there's an opportunity for the purchaser to inspect the goods that are delivered, and then accept or reject those goods. And similarly, when it comes to changing the contractor scope of work, we're used to talking in terms of change orders and construction change directives. Those terms also tend to be alien in a owner-vendor agreements. In owner-vendor agreements, you see terminology like canceling orders, and then if there's a need for to increase the scope of work of the vendors, you would have subsequent orders. You don't have the same kind of mechanisms like a construction change directive that you would have in a construction contract. And the entire way in which vendors get paid is different from how contractors get paid. They couldn't be two more different methodologies for payment. Contractors tend to get paid after they've completed their work through the application for payment and certification for payment process. Vendors quite often get prepayment. They get deposits in advance, and then they do their payments by invoicing with either some or no oversight by the architect or the designer. So big difference in just contract terminology. And continuing with the difference in contract terminology, there is a very fundamental difference in the type of law that applies to construction and design contracts, and that occurs with vendor goods contracts. Most of you are probably not going to be at all surprised that we have a slide about the Uniform Commercial Code. This is something you probably thought was coming up at some point. And you cannot have a discussion about FF&E contracts without discussing the UCC and its impact on FF&E contracts. So just as a very high-level overview, the UCC is a modern body of law that specifically applies to the sale of goods. And goods are items that are movable. It's the kind of items we've been talking about. In law school, they'll teach you for an entire year about the Uniform Commercial Code and how it is different than your traditional common law of contracts. I've probably got about 8 more minutes to talk about it, so I'm not going to be able to do it justice, but I at least want to get you oriented and to make sure you understand that when you are dealing with FF&E contracts, goods contracts, you're dealing with a whole different body of law. And as architects, I think that this body of law can be tricky because we think in terms of service contracts primarily, because that's the kind of contracts that we find ourselves in when we are engaged by an owner in a design project. We're providing services, not goods, of course. So real quickly, what is the UCC? Like I said, it is a model set of laws that was first produced back in the early 1950s. Just like your building code, it is a model set of laws that every state has adopted. And the idea being that if you are transacting business, buying and selling goods between two different states, that you would have the same kind of rules would apply to each party and to each scenario. And the goals of the UCC are pretty clear. The application of them can be a bit muddy sometimes, but the UCC is trying to break away from the rigid rules of contracting that you would find in service contracts, in the common law of service contracts. So when you're looking at a service contract, the contract between an owner and an architect, the law that applies to that is what we call common law, and it's the same kind of law that we get from the time when the United States was a colony to England. So those kind of rules and laws are very well established and have been around for a very long time. The UCC tries to fix some oddities that can happen by the rigid application of common law rules to commercial transactions. The goal in the UCC is to find a contract if the parties have acted like there was one. The UCC will do things like supply terms that might have been left out because quite often it's possible that there is no definitive writing in a sale of goods scenario. So I'm going to do a little example because most of what I've been talking about right now is conceptual, but this is just one example of how the UCC operates and that it is different from the common law of contracts. So start by imagining your typical owner-architect agreement. The owner and architect will probably go back and forth a number of times to negotiate the terms of that agreement to make sure, you know, that they settle on a set of terms. It's very unlikely, but it happens. But it's pretty unlikely that the parties are going to get started doing any real work. The architect's not going to start performing their services usually. The owner's not going to start paying the architect for their services until they get a contract in place that memorializes the understanding between the two parties. In the sale of goods realm, that assumption that there will be one writing that both parties have agreed to is not always true at all. There are many, many, many instances in which there are two different forms in which the parties have exchanged, but they've not totally agreed to all the terms. So for example, let's just say that I'm an owner and I want to buy 10 copy machines and I see an advertisement for those copy machines for $1,000 each from a company on the internet. I send them a purchase order that says, I agree to buy 10 copy machines for $1,000 a piece. I'd like delivery within 3 days. Here's my check for $10,000. And I want to be able to make claims if I have any claims about, you know, defective copiers or something within 5 years' time. I need 5 years in order to make claims. What quite often will happen is the seller of those copy machines, they'll cash my check. They will send back a confirmation that says we agree on the price, we agree on the number of items, and in fact, here we're going to go ahead and ship your copy machines out to you in the time in which you indicated. But there's one little caveat in the terms and conditions that the seller sends back that says any claims about these machines has to be made within 1 year. So if you're in a common law situation, a traditional common law situation, you don't have a full meeting of the minds. What you actually have is an offer and then a counteroffer that no one has fully accepted, neither party's accepted. You certainly have a contract because the parties have performed, but there's no writing that the parties have agreed to. The UCC takes those old common law rules and throws them away. It says the parties clearly intended to have a contract. And in fact, they've agreed to 4 or 5 things that are the most important aspects of this contract. And those things that they agreed to will become a part of their contract. So they look at the 2 writings and say everything that the parties agree to is part of the contract. And the thing that they don't agree to drops out. So that 1-year and 5-year provision for statute of limitation drop out, and the UCC will actually supply a term, a default term, to make up that gap. And the default term in the UCC for statute of limitations is 4 years. It's a little tricky, and there are a number of rules like that in the UCC, but you need to become a little bit familiar with them, particularly if you're going to be negotiating FF&E contracts, or if you're going to be acting on behalf of the owner in some way with regard to furniture vendors and goods vendors. So I hope that gives you a little bit of an overview of what the UCC is all about, and at least impresses upon you that the legal landscape when you're in an interiors project, particularly dealing with furniture, is very different. So are your contracts. So I'm going to turn it back over to Sal, and he's going to talk about give us an update or a summary of updates to the AIA's interiors family. Sal?
Thank you, Mike. I will, and thanks for the talk about the UCC. There's no way I could have done that. So we'll give you a quick update, the summary of the interiors documents, that the interiors family, as we call it, that was updated. They've all been updated and in our minds greatly improved. We've added some. So on the next slide, you'll see the new family. And if you can just focus on the top 4, which are the B documents, and the B documents are the owner architect agreements. And it's the B152, 252, 253, and 254. The B152, the flagship document in the interiors family, the previous one we obviously updated was very limited, and now we've restructured it to work for various size projects and types, hospitality included. It was not very well organized for hospitality projects, but it's a standalone document. That's what you would use directly with the owner for in interiors designs and FF&E combined. The other 3 documents, the 252, 253, and 254, are what we call scope documents. We'll get into that later, but basically you would take one of those and use it with a B101 or B104 agreement. They get married up together. They're defining more scope in these particular documents. And then quickly, the 252 is for interior design and FF&E. The 253 is just FF&E, and the 254, which is new, by the way, and that's the document where you would be the purchasing agent on behalf of the owner and procuring him. During evaluation, we discovered that a lot of architects were actually doing this work, and many people were missing out at the opportunity, so we created a document for you to use. The last 3 documents are owner contractor documents, the A documents, 151, 152, and 751. The 151 is standard form of agreement for full services. It used to be a 2-part document. We've condensed it into one. We made it a lot more user-friendly for our membership. And the new one we added was a purchase order to go along with the other document, the B documents. It has terms and conditions. We call it FF&E Light, the purchase order, and we'll explain that a little bit later. In the last document, the invitation and instructions for quotations, if you're familiar with the invitation and instructions for bidders, under construction you would use a bid. FF&E contracts are quoted. And again, that's another one of those terms, as Mike mentioned before. It's very difficult for me to get used to that, but in the interiors world, it's very common. So let's take a little bit deeper dive into the B documents, which is the ones we really want to focus in on right at the moment. The B152, again, it's a scope document, which the B152 is a standalone document, and it's to be used in lieu of a B101 or B104. But there are some differences, and the question is, why do we even need this? Why don't you just use the B101? If you remember before, when you introduced FF&E, it gets more complicated. Well, one of the things that we noticed was in a lot of interiors documents, and we heard this, the feedback from our users, is that programming is very important when it comes to interior design and FF&E. So we had to add programming to the services under B152. In the B101 and the B104, the programming is not a basic service under the B101. So that document doesn't lend itself very well when you talk about interior design and FF&E. So we added it as an integral part of the services under the B152. So that's really important. That's number one. We also have to acknowledge that FF&E and construction work on a project, they have separate budgets and schedules, as we talked about before. So in this document, it addresses separate budgets, one for FF&E, one for construction, and separate schedules, one for each of those as well. This contract doc is B152 will allow the architect to provide the owner separate fees as well. So you have schedules and budgets that are different. Now you can provide separate fees to your client, fees for interior design, construction work, and fees for FF&E if you have both of those in this particular project. This helps position the architect to better determine their scope of work, which is one of the complaints we heard with trying to shoehorn some of those other documents into an interiors design project. And this came about because we interviewed many architects who actually use these documents. So let's look at just another explanation on the next slide. The B152, look at the phases if you broke it down graphically. So let's say you have a project with both interior design, obviously, and which is construction work, and you have FF&E in the same project. So you have normal programming under these, and again, in the B101, that's not a basic service. It is now. You also have schematic design and design development. For both interior design and FF&E, these three phases are completed pretty much at the same time, if not exactly at the same time. It's when you get into construction documents, when you try to build a construction package and an FF&E package, which are two separate packages, possibly done by different people, is when the things more or less separate, and the document now reflects that. So we have in the 152, it's broken down. You'll have construction documents, construction procurement, and construction phase services that will be discussed and outlined. And you also have a section for FF&E documents, FF&E procurement, and FF&E contract administration, because there's not necessarily installation for FF&E. There's delivery of goods. Construction occurs normally before FF&E, and that's why you see the separation normally. I'm sure there are times it can happen at the same time, but under normal conditions, it's well before, if not totally separated, including the design may be separated as well. Now you have the option of FF&E being completely separated if needed to be, and you can handle it in a later time frame. Why the separation? The feedback we got from users, it's that obvious and simple. They expressed that these were problems trying to use the old documents and also the B101. But if you wanted to do them at the same time, it can be done. So let's go a little bit deeper into the FF&E contract administration, our role as architects. The architects in contract administration using the 152 will assist the owner in doing things we normally do, coordinating schedules for fabrication of FF&E, delivery of the FF&E, and installation, because some FF&E can be installed, and that's really important here. But we'll also review submittals. We'll make job sites visits. It might not be on a regular schedule. It might be set times or a number of visits. But the other thing that's really important are the last two elements. The preliminary, there's two types of inspections. This is for FF&E specifically. Unlike when we have inspections under normal construction and for substantial completion and final completion, now we have what we call preliminary inspection and acceptance inspection, and they're defined differently, and we'll talk about them later, but basically, when you do a preliminary inspection, you're verifying that the goods have arrived. It's as simple as that. And if you an acceptance inspection, you're, as the architect, verifying that everything is counted, they're corrected, correctly submitted and delivered. It's what you ordered, it's the right color, things like that, and you accept it. We'll talk about that a little bit more later. We'll get into some more specific details. But let's go back and let's talk a little bit about the scope documents, the B252, 53, and 54. Again, these are scope documents. They have to be used with another agreement form, and specifically the B101 is what we try to model as a dovetail document. The scope documents define specific scope of services. That's what we're trying to get across. These are scope documents, as opposed to the B101, which would be married up with. That document defines the business terms of your contract with the owner. For example, payment, things like that. The scope documents get into the real deep dive. So I'm going to turn this back to Mike, and he's going to talk about some of these documents in more detail.
Thank you, Sal. So the next document we're going to be talking about is the B254, Purchasing Agent Scope of Services. This is a new document for us. It's very unique to the library of documents at the AIA. And when we first set out to, a couple of years ago, to update the AIA's Interiors family of documents, we interviewed a number of architects about their practice. Architects who did all different types of work: commercial, corporate commercial, interiors, hospitality work, folks who did, residential projects. And one thing we learned was that pretty uniformly, owners on projects expected the architects to be involved in some way in procurement. Now, maybe it's because, the reasons for that kind of varied. I mean, often owners feel like and believe that architects or designers can get better deals on furniture, but also often owners just don't want to be involved in those kinds of contracts, and they would rather take just a more hands-off approach. So that was something that architects were always faced with, at least the ones that we interviewed. But what I found really interesting was that the architects' responses to that need or to that expectation varied quite a bit. Some architects were content and were comfortable doing just design work only, and having, maybe have a little bit of interaction with vendors as far as helping, facilitate a transaction, but really just wanted to keep an arm's length transaction when it came to procurement of goods, and allow the owner to procure goods directly through the vendors. Other architects that we talked to were wanted to be in the middle of the transaction between an owner and a vendor, and even buy and resell to the owner, and that was a big part of their business, was that they could make a fee based on a markup of the cost of furniture of the goods to resell them to the owner. And still other architects that we talked to wanted to facilitate transactions in some form of an agent or a representative capacity, but not actually buy and resell goods. We also, I think, we're noticing when we talk to folks that we interviewed that architects were a little bit kind of fuzzy on what responsibilities and liabilities might come out of the roles that they were assuming. So what we created in response to this issue was the scope of services that I'm going to talk about, which is which positions the architect as a disclosed legal agent of the owner. Now, just a couple of caveats here. There's absolutely nothing wrong with any of the approaches that we heard from architects that we interviewed. If you want to take a hands-off approach, if you want to be a buyer and a reseller, that's perfectly fine. And as long as you know what you're doing and you understand what you're getting yourself into, that's perfectly fine. We simply wanted to create a document that would that might fill a void, that folks could use, that would be handling these kinds of situations in a risk-managed way. And the most risk-managed way that we could think of doing it was to position the architect as an agent. This allows the architect to enter into contracts with FF&E vendors on the owner's behalf, but it does not make the architect a buyer and a reseller of goods. Again, there's nothing wrong with that, but that's not what this agreement is, and this is just one way to do it. There are many other ways to do these kinds of services. I don't normally like to read from my slides, but I think that the first two sentences in section 123 of B254 are so important that I'm going to read them. The owner understands and agrees that it is not purchasing FF&E from the architect. Rather, the owner is purchasing FF&E from vendors who are independent of the architect, with the architect acting as the owner's agent in such transactions. And that is the heart of what the B254 tries to accomplish. So this is a great responsibility to effectively be acting as a power of attorney in a very limited capacity on behalf of the owner. And I'm going to talk about some safeguards that we have in this scope to protect the owner and the architect from overreaching. Before I do that, I have to talk about insurance. And if you're going to be doing these kinds of services, in fact, if you're going to be doing anything as a designer, an architect that goes beyond design and that gets towards procurement in any manner, you need to be talking to your professional liability insurance carrier to make sure those services are covered. What we found is that there are, I think, 60 different professional liability carriers out there, and their policies range, pretty drastically sometimes, especially when it comes to services that might be excluded. We know that there are some professional liability policies that will not cover these in any instance, but we also know that there are some that will cover them as long as they are done in conjunction with the architect's traditional design services. So if you are doing the underlying interior and FF&E design work, and then you do FF&E procurement services, there's a chance that those services will be covered under your professional liability insurance. So just make sure you make that call and talk with your broker about that. Now on to safeguards. How does the B254 safeguard the owner and the architect from what can be a risky proposition, which is having the architect enter into contracts with vendors on the owner's behalf? The first way, and the most obvious way, is that prior to entering into a contract on the owner's behalf, the architect has to get permission. The architect has to disclose, here's the piece of furniture I'm buying, here's the price, here's the quantity, and get written approval. That sounds pretty obvious, but it is something that you can imagine if you just got a handshake agreement or a phone call from the owner, there could lead to discrepancies or confusion later on. So that's a pretty threshold idea. And the next set of safeguards we've actually styled these as limits on the architect's authority. And these are really things that the architect probably doesn't want to be doing if they intend to act as an agent, not as a buyer and a reseller. And there are things like, clarifying that the architect is not going to be purchasing and reselling to the owner, clarifying that the architect is not going to be, for example, delivering or installing FF&E on the project, or taking title to the FF&E, or even paying for the FF&E out of the architect's own funds. Again, all of these things are, in a different scenario, if the architect was being a buyer and a reseller, they might be fine activities to do. But when you are just being a purchasing agent for the owner, these are things that you probably shouldn't be doing, because they are all things that could add risk to your plate that you are not getting compensated for. Last thing I have to talk about in the FF&E procurement realm is the topic of sales tax. So as a threshold question, you need to be asking yourself, are you buying and reselling goods? Are you buying from someone and then reselling to the owner? Chances are, if you are buying and reselling, then you're going to be responsible on some level for collecting, recording sales tax on those goods. If you are not buying and reselling, if you are acting as an agent to the owner, or if you are just doing design work and not stepping into the realm of FF&E procurement, then you probably don't have to handle sales tax. But I want to impress upon everyone who's listening from perhaps all over the country that the answer to every sales tax issue is look at the laws of your state, because they do change state to state. There are some commonalities between them, but at least the states that I've looked up, and I've probably looked up a half a dozen or so, there's always a pamphlet out there somewhere from a state agency describing what a designer or an architect's responsibility is when it comes to sales tax. One very common issue that you're going to run into, and that most states have at least addressed in some way in their literature, is the question of whether or not the purchaser has to pay sales tax on professional design services. And while I can't speak for every state out there, I can tell you that at least a handful of states that I've looked at, Florida, Alabama, I think New York as well, there is a test that that will be applied to whether or not this question of whether or not sales tax needs to be collected on professional services. And that test comes down to whether or not the fee for the architect or designer's design services is distinct and separate from the fee for the goods themselves. If it is not distinct, you'll probably have to, the owner or the purchaser will probably have to pay sales tax on both the goods and the design services. If it is separate and distinct, then there's a more likely that you will not have to pay sales tax on the professional services. Again, this is just a primer on this issue. Definitely look into the laws of your state on this issue. I'm now going to turn it over to Sal. He's going to talk about owner-vendor agreements.
Thank you, Michael. And let me just say on these the owner-vendor agreements, we call them vendor agreements, is that the A151 and the A751, which is the invitation and instruction for quotations, those were both released in this past spring of 2019. The A152 with the purchase order, that is scheduled for release right about now if it hasn't been released already, but it will be released shortly here in the fall. So let's take a general overview of the vendor agreements. Again, all three of them. The difference is, and again, I had a tough time grasping this myself. FF&E laws and customs are noticeably different than typical construction laws. Next slide, Mike. Where, again, we talked about goods versus construction. And vendor agreements address the goods and delivery, not install. Those things are very apparent in these vendor agreements. The language is carefully written. We did develop a new purchase order because it was demanded. And now I will have to say that, and I'm sure you've all experienced this, that a lot of vendors, all of them, have their own purchase order forms. I can say this with reasonable truth that they're often very slanted. And we were very concerned about that. And they're all different. There's no two that were basically alike. So the AIA, when we developed one, we designed one to be extremely fair right across the board. But one thing you have to understand is that the new purchase order and the vendor agreements in general do increase the architect's involvement. Architects are much more engaged in the process, which is a good thing. As we mentioned before, you're now part of the process. Hopefully you've done the building, now you can do the FF&E. The advantage is that you will ensure that your design intent is achieved and not compromised, which often happens when we're not around and our eyes aren't on the ball there. So let's specifically look at the A151 in the next slide. Formerly, before it used to be 2 parts. Now we've condensed it down to 1 part, just made it in the A151. It's intended for larger projects. That was the intent of it. It didn't make sense to have it for just smaller projects, but there's fully negotiated terms in the agreement. I think you'll find it very usable. This is where you got to understand, this is where the vendor sells and installs the FF&E. The vendor's fully engaged as well. The key aspect here in the A151, it's not just delivery, it's installation as well. That's a very important point to make sure everyone understands that. So this document has definitely been revised. So let's take a little bit deeper dive on the next slide. These are some of the terms we talked about before. We want to show you them. They're in Article 8 of the A151. Excuse me, 151. We have 2 inspections I mentioned before, the preliminary inspection and the acceptance inspection. In both cases, particularly on the on the preliminary inspection, we're reporting the findings to the owner. We have to report. That's our job, to report these findings. Once they're in place and we come into our acceptance inspection, it's similar to a substantial completion. At that point, you're doing a full inspection and signing off on it. And as Mike mentioned before, this is where it's really important. At this point, things get changed over to the owner, and I'll talk about that in a second. But there's 2 inspections. They're clearly defined in the A151. If you find this document is too robust, it's too complicated, we developed the A152, and that's the one that's going to be released here in the fall. We joke around that it's the FF&E light. It's a little bit more less complex and not as robust. But we also addressed in the next slide is completion. We've added a completion schedule to this A151, which was lacking before, and this ties into the acceptance. By the way, there's a fill point. You pick calendar days, you could pick a date. There's a lot of things you can do. You can edit it any way you'd like, but it's very important that you have an acceptance date, if it's important for your project, that is. If it's not, you can address it another way. But we've given you the option now to have an acceptance date, a completion date. Now with that, on the next slide, anytime you have acceptance and dates and things like that of nature, there's changeover, and this is where the title and the risk comes in. When you at the acceptance is basically the acceptance inspection is basically equivalent to substantial completion, and everything's transferred from the vendor to the owner. The title, insurance is transferred from one entity to the other, and that's the point we want to make. And it wasn't clearly defined before. There's a lot of gray areas. Now we made it really clear. Now, I will say vendors don't like some of these things. They certainly don't like this one, because they like to know that when they delivered the item and we've just did a preliminary inspection, that the things get switched over and turned over to the owner. That's not necessarily true, and that's why we wrote the documents this way. And lastly, payments. And it's really important to address this as well in the next slide. The payments are always unusual, and I think Mike mentioned this before. Vendors, unlike typical construction, expect to be paid differently, and most of the time in advance. I'm not used to that. It's a funny thing for me to accept, but I realize that's in the vendor world. That's typically common to them. Vendors generally do not agree to get paid after delivery, but you can set it up this way. You have the option of setting up payments in any way, shape, or form you like. The payment terms are very flexible in this document, and it allows you to adjust it in any way you feel fit. But I will note in paragraph 2.2.2 up above, 2.2.2, before payment is made, we as architects have to do our diligence, and the vendor must submit an invoice, and we have to verify it. That's really important, that they have to submit an invoice. And again, they're not used to doing those kind of things. But we made it we think it's really simplified and straightforward in this particular case. I'm going to turn it back to Mike, and he's going to talk about the world of warranties.
All right. Thank you, Sal. We've only got about 5 minutes here left, so I'm going to I'll just touch on warranties a little bit and some issues to think about. And and we'll talk briefly about the purchase order, and we'll give you some contact information if you want to reach out to us for if you have any questions. When it comes to warranties, there's really two types that you should be thinking about. There are implied warranties and there are manufacturer's warranties, contractually created warranties. Implied warranties, I won't talk too much about right now because, like I said, they are implied and they are implied in every sale of goods. They're things like if someone is selling you a product, they inherently warrant that they have title to that product. That's pretty fundamental and obvious. When it comes to manufacturer's warranties, though, these are things that not all goods come with a manufacturer's warranty, right? They can be as broad or as narrow as the manufacturers want them to be or make them out to be. But something that you will need to make sure you have if you are an owner, or if you're an architect who's working in procurement in some fashion, you'll want to make sure that there is a provision in your owner-vendor agreement that effectively assigns manufacturer's warranties onto the final purchaser. That might not always work. There may be manufacturer's warranties that don't allow such an assignment, but in many cases that will work, and it will allow the final purchaser, the owner, to have the benefit of manufacturer's warranties whenever they may need to make a claim against them. And that's what you see in section 9.2 of this slide. As Sal mentioned, we are also working on, or we're finishing a purchase order. It's a highly condensed version of that document that Sal mentioned earlier, the A151 owner-vendor agreement. This purchase order, I wouldn't expect it to be on our website before the end of the year, but our software team might surprise me. But it's coming up here soon. It is for smaller engagements that are specifically where the vendor is only selling and delivering. If the vendor is doing any on-site work, such as assembly, installation, the A152 is not going to be the right document for it. It just does not take into account all the nuances that go into on-site work. But if you just have an engagement where you're for the sale and delivery of goods, A152 is perfectly useful. It is a one-page document that has 4 pages of terms and conditions, which is in an Exhibit A. So be on the lookout for that here in the next few months from us. And importantly, this can be used on any types of goods. I mean, we've been talking in terms of furniture here over the last hour or so, but this can be used for anything, and it's couched in terms of purchaser and seller, not owner vendor. So it's a more flexible document than you might think from listening to this presentation. Here's a snapshot look of what the purchase order is mostly going to look like. A few things have changed here as we've been putting the final touches on this, but the first page of the purchase order is all those things that are commonly negotiated, right? The price, payments and delivery. I just want to point out that by default, the delivery is that the vendor will deliver the goods to the project site. If the parties can obviously change that if they want. We are coming up on the end of the hour, so if we have any questions, please send them to us, and we'll get back to you offline. I want to be respectful of everyone's time, so we probably won't have time to do live question and answer right now. But I want to point out some resources if you want to know more about anything that we have to offer at AIA. You can email us at docinfo@aiacontracts.org. You can get on our website. We've got all kinds of webinars and guides and materials on there that you can peruse. And we also have tech support if you're using our software program. So again, I want to thank everyone for attending this presentation, and we really appreciate it. Thank you.
Thank you very much.